On October 31st, 2023, the U.S. Occupational Safety and Health Administration, OSHA, engaged in a memorandum of understanding with the National Labor Relations Board. That memorandum is going to have profound impact upon employers as they experience everyday efforts to comply with the Occupational Safety and Health Act, as well as to comply with investigation efforts by the agency. We're going to talk about that memorandum of understanding and how it impacts employers on the December 13th, 2023 episode of the OSHA 3030 with Manesh Rath. Well, hello, everyone. I'm Manesh Rath. Welcome to the OSHA 3030. I'm an attorney at the law firm Keller and Heckman in Washington, D.C. I've been representing management side in the field of workplace law for 28 years, and I'm joined today by my colleague and friend Taylor Johnson, also an attorney here at Keller and Heckman. Taylor, thank you for joining the OSHA 3030.
It's a pleasure as always, Manesh.
Well, we have an important topic today, I'd say.
Yes, absolutely.
Because in the past month, the two agencies, the National Labor Relations Board and the Occupational Safety and Health Administration, entered into a memorandum of understanding with each other. It's not the first one between the two.
No.
But it is important, and it renews our interest in the areas of overlap between pure labor law and OSHA law. And I think we should discuss first what we're going to see inside the four corners of that memorandum, and what then we think are some of the implications of that memorandum for our friends in the OSHA 3030 community, the employer community.
Yeah, no, I think that's a great idea.
Okay.
So we'll start with that. We'll go into Section 7. There's going to be a lot of talk of Section 7 today of the National Labor Relations Act, and then Section 11C of the OSHA Act. We'll also, so we'll talk about these NLRA rights and how they apply in the context of safety and health. We'll go into Weingarten rights and whether or not those are going to come into effect here with this MOU. We'll talk about surveillance and confidentiality at work sites, and how surveillance for safety, confidentiality of safety investigations, how those change now in the context of this MOU. And we'll also talk about unionization efforts. We covered this recently in one of our 3030 episodes about the walk-around rule, sort of coming back up to the surface here again with this new MOU. And then finally, as always, we'll wrap up with what employers should do, some practical takeaway items for you to bring back to your workplace.
That's right. And oftentimes we go off the record afterwards for just the members of the live program. And today this is pre-recorded, so we will be skipping the off the record portion, but we invite all of you in the OSHA 3030 community, if you have questions about this material or any other OSHA law question, feel free to shoot either Taylor or me an email anytime in the month in between this episode and January's episode. We love chatting about OSHA law. And if it's a black letter law question that we can answer off the top of our heads, we're more than happy to share our thoughts on any questions you might have. So see if you can stump us. So with that said, why don't we get into it? Let's talk about the memorandum first, Taylor. I think that the first thing to say is that this is only a month old, and that the first area of interest to me seems to me to be that the memorandum calls for the two agencies to be able to broadly share information gathered in their own activities. So, for example, on the OSHA side, if they're conducting an OSHA investigation, that they have under this memorandum of understanding the ability to share anything gathered under their investigatory efforts with the NLRB. Vice versa, if the NLRB learns any information, then it would have the opportunity under this MOU to forward that information over to OSHA.
Right. Now, I think that's probably the most important thing, and we'll get into a little bit more about that sharing of information.
Yeah, I agree.
And then I think, the next thing would be coordinated investigations and enforcement. So in instances where there are overlapping statutory violations, the MOU says that OSHA and NLRB will now be able to coordinate and run a joint investigation together.
Probably a narrow set of facts that would allow for coordinated investigations, but it's important in those instances where that might actually arise. Then the memorandum of understanding calls for reciprocal training, education, and outreach. This is an opportunity for the agencies to train each other's staff, and for the NLRB, importantly for us in the OSHA 3030 community, for the NLRB to be training OSHA compliance officers on what to look out for in order to potentially refer more matters to the NLRB. Of course, it goes in the opposite direction as well.
Right. And then lastly, so if you're in a state plan state, you're wondering what this might mean for you, the MOU does say that that OSHA and NLRB expect cooperation out of those OSHA agencies and state plan states as well.
Yeah, that's right. The OSHA Act is unique in the sense that it allows states to carve themselves out from the federal statutory scheme. That doesn't exist in the National Labor Relations Board legal jurisprudence. But because of that, the memorandum contemplates the idea that the state plan states that have opted out would fully cooperate in the spirit of this memorandum of understanding.
Right.
All right. So let's talk about sharing of information. I think this is important.
Yeah, I think that this is probably the key piece here that we wanted to cover. So with respect to sharing of information, the MOU says that OSHA will provide potential victims of unfair labor practices who have not yet filed a complaint with NLRB with NLRB contact information. If they uncover that there's a potential labor violation during the course of an investigation, they will then provide that employee with sort of a direct pipeline to NLRB.
Yeah, and Taylor, if the employee files an 11C complaint, this is the whistleblower complaint in shorthand, then OSHA will process it. And if facts come up that implicate anything of interest to the National Labor Relations Board, OSHA will forward it on. And if the 11C complaint is untimely, OSHA will advise the complainant that they could still potentially alter their complaint such that it might fit under the NLRB's sphere of interest or jurisdiction.
Yeah, that one really jumped off the page, I think, to me.
Well, I think that the other issue that jumped off the page for me, Taylor, was that the NLRB and OSHA can share information with each other that are learned in their respective investigations.
Right.
What does this mean? Well, it means that when the NLRB is conducting a hearing or conducting an investigation, that it has the opportunity to forward matters to OSHA, and that OSHA now has an alternative pathway to probable cause to conduct an investigation of its own.
Right.
And I think that that's significant because now it has essentially deputized the entirety of the NLRB's resources to augment the compliance, safety, and health officers core of OSHA to consider whether or not facts or circumstances are investigation worthy in the minds of the area directors at OSHA.
Yeah.
The other thing that this implicates is that when OSHA is conducting an investigation, information that's supplied by the employer in good faith in the pursuit of that investigation or in the course of that investigation will now be information that the employer has to contemplate the possibility that that information will find its way to the National Labor Relations Board. Thus, information that the employer may not have considered any objection as meritorious to the provision of data to the Occupational Safety and Health Administration may nevertheless be objectionable on alternative grounds with respect to the National Labor Relations Board. And thus, an employer is now burdened with considering a larger set of objections. This will also have the unintended consequence of frustrating the efforts of the Occupational Safety and Health Administration's compliance officers, because information that it would have otherwise more readily obtained may be objectionable on alternative grounds consequent to this memorandum of understanding. Yeah. Now, I can't at the moment come up with any examples of data that is objectionable under one scheme but not under the other, except for the objections that are related to relevance. Now, a larger body of issues become relevant that wouldn't have under just an investigation into the Occupational Safety and Health Administration. So I think that by broadening the theater, the compliance officers' efforts have now also been potentially frustrated in their ability to rapidly get the information they needed. So that I think is a really critical point, and it's an important practice point for employers and their counsel to consider when furnishing data in response to an investigation request. Of course, all of this is within the understanding that employers should be fully cooperative to all Occupational Safety and Health Administration investigations. But it also is offered within the scope of a commonly held understanding that reasonably raised objections are still within the prerogative of employers after all.
Yeah.
So let's go on. But I think that that's an important point to consider now that they'll be freely sharing information. There's one more point, by the way, before we go on. And that this memorandum of understanding calls for the exchange of information. And when that information is exchanged, each agency may produce it to third parties under the Freedom of Information Act. And that's expressly laid out in the memorandum of understanding. So when you look at the Freedom of Information Act, and the memorandum of understanding says that if one agency has received information from the other, it must still go through its FOIA analysis before determining whether a datum or document is producible pursuant to a FOIA request. That essentially means that when an employer produces documents under an OSHA investigation, it has to consider the possibility that it will find its way to the National Labor Relations Board, and that the board may be faced with a FOIA request, and that it will have to conduct its own FOIA analysis and potentially produce that document, which was intended for a compliance officer.
That's a great point.
So now you've got third parties as well in the mix.
Right.
And again, it raises the question in that instance that should be raised by the employer and their counsel of not only what objections should be filed, but also what confidentiality stipulations should be arrived at first, or what markings the documents should receive and enjoy that designate them as confidential or fitting under one of the enumerated FOIA exemptions. Okay. Let's talk about Section 11C, since we talked about that a moment ago.
Yeah, so we brought that up sort of in the instance of, an untimely 11C complaint can now be something that OSHA, kind of forwards on to NLRB. So you get sort of, another bite at the apple, so to speak. So what is 11C? What types of whistleblowing, is covered? So 11C in the OSHA Act states that employers cannot discharge or discriminate against employees who file an OSHA complaint, cause or initiate a proceeding under the OSHA Act, or testify or otherwise cooperate, speak with, an investigator at the site.
Right. An employee who believes that they have an 11C complaint has 30 days to file that complaint with the secretary, and then it goes through the 11C process. OSHA has administrative law judges that are designated to 11C, and they actually preside over whistleblower complaints under 20 other federal laws, 23-ish other federal laws. And this is an important point because the complaint, the content of that complaint may implicate an evaluation of whether or not the memorandum of understanding applies, specifically whether or not OSHA, based on the contents of the complaint, should advise the complainant to file a complaint instead or in addition before the board.
Right.
I think the other important point here is that it's not just protected activity under 11C when an employee raises a complaint about safety or health, or participates in an investigation by the administration, or testifies, but it also when an employee refuses to engage in conduct or activity that's he reasonably or she reasonably believes and in good faith believes to be a situation that would create imminent grave danger.
Right, that's right. And there's a regulation that protects the employee in that instance that they refuse to work if they believe that it's going to be unsafe. You can envision that type of complaint would also be something that could potentially find its way over, to the NLRB.
Yeah, particularly if you look at Section 7 of the National Labor Relations Act, which protects employees' rights to engage in concerted activity. Concerted activity means anytime two or more employees connect with each other on the basis of or on the topic of any terms or conditions of work.
That's right. We've always figured, Manesh, that covers, two employees discussing unsafe or unhealthful work conditions. What's interesting here in the MOU is you sort of see OSHA and the NLRB both opining that they agree, and that it's actually right there in the MOU. It says both the NLRA and the OSHA Act protect the right of employees to complain to management about unsafe or unhealthful working conditions. So right there, we see that they're bringing Section 7 to cover those types of conversations.
Right. And we take it on faith that's squarely within the ambit of Section 11C,
sure,
that an employee has an unfettered right to complain to management about what they in good faith believe to be an unsafe or unhealthful working condition without fear of retaliation. However, this now also arguably protects, and I would have taken the position that it always had,
right,
to employees, non-management employees, discussing what they in good faith believe to be unsafe health or safety conditions at the workplace as well. That arguably, although that may or may not be protected under 11C, would be considered a concerted activity under Section 7 of the National Labor Relations Act.
Right. So Section 8A1 of the National Labor Relations Act, and this sort of gets into what employers can't do. So there's a few things here. The first is threaten employees with adverse consequences if they engage in union or other, concerted protected activities. So if the employer is essentially, inhibiting on those Section 7 rights to engage in these concerted activities, then that would be prohibited conduct under Section 8A1.
Right. The bottom line is, when it comes to protected rights, employers need to be conscientious not to engage in any conduct that could be interpreted or misinterpreted as threatening employees, interrogating them, making promises of future benefits,
right,
in exchange for taking a non-union position, and surveillance of employees who are engaged in protected activities, or surveillance of those protected activities. But the two that really jump out as having significant crossover with the Occupational Safety and Health Act area of law are the idea of interrogating employees and conducting surveillance. So let's talk about those for a moment. When an employee, let's say there's an accident or an incident, safety and health incident, and a safety and health professional comes to find out more about what are the multiple causes that led to that incident.
right,
To the extent that that could be misinterpreted as an interrogation, that is the kind of exchange that safety and health professional has to conduct themselves very carefully about, in order to make sure that they don't run in violation or raise the possibility of an alleged violation of Section 8A1.
right,
The same goes for the kinds of instruments that workplaces have set up as a matter of routine for the security of the premises, like surveillance cameras, etc., or even other sorts of monitoring activities, where that could be misunderstood or misalleged to be directed at an infringement of an employee's 8A1 rights to engage in protected activity free from surveillance.
right.
So those are two issues that I think cross over on Section 8A1 in the field of safety and health.
Absolutely.
A lot of accident investigations depend on the kind of camera monitoring or closed circuit monitoring that you'd see as a very ordinary course of business at a lot of workplaces.
Yeah.
Let's go back to questioning employees about incidents or accidents. When a safety and health professional or a member of management asks employees questions to try and understand the cause or causes of an incident or an accident, theoretically, to the extent that that line of inquiry could result in any disciplinary action for that employee or anyone else, arguably an employee could invoke a right under Section 7 of the National Labor Relations Act to have a union representative present during that interview. That's an important point that I think the memorandum of understanding operates to affect, because now, if one or the other agency believes that that right to representation might have been ignored or infringed upon, then I think you're going to see a referral to the other agency.
Right. And I think this is something that you may not have, as an employer, really had at top of mind in the context of an OSHA investigation. I don't think you'd typically be thinking about, union representatives. But now with this MOU, I think that that's something that you need to be aware of. If an employee requests a representative, business agent, a fellow employee, these are often referred to as Weingarten representatives, to be aware of that, even if it's just the context of an OSHA investigation, that
Right.
Refusal to grant the employee that request could then directly be funneled to NLRB, and then you've got a whole different set of problems.
Yeah, that's right. And so jumping ahead to our last section that we always stick in there, what employers should do, I think that employers should advise and train their safety and health staff as well as their plant managers on Weingarten rights.
Absolutely.
Surveillance restrictions, we talked about this a moment ago. The kinds of closed circuit or video camera monitoring that takes place for a host of issues, including inventory management, as well as safety and health, etc. They certainly run right up to the boundary of the kinds of surveillance that would be unlawful. This would be examples of lawful surveillance. Unlawful surveillance would involve surveillance that's directed at protected activity under the National Labor Relations Act. So I think it's important when setting up surveillance systems for other legitimate business purposes to make sure that the bases for the surveillance system are documented, and that the design of the system is in conformance with the purposes, stated purposes of the system.
Right.
So for example, the employee break room may not have surveillance cameras in there
Yeah.
because it doesn't fit within the scope of the stated purpose, let's say inventory shrinkage or just workplace safety and health for safety intensive operations like operating heavy machinery.
Right. That's right. And then I think, why you're using the surveillance too is going to be something, we see in the context of what employers shouldn't do. Back to section 8A1 there, using it to, stifle unionization efforts, things like that, just making sure that there's this balancing test between why you're using it and that there's a legitimate interest and you're not sort of using it to cross over the line into something that would otherwise be, obstructing a protected activity.
Yeah, I think that's right. All right. So let's talk about confidentiality where accident investigations are concerned. It's typical for safety and health professionals, in order to preserve the integrity of an investigation, to want to sequester the witnesses and not have a lot of chit chat in between their interviews between witnesses, so that you can minimize the risk that maybe two workers try and get a manufactured story coordinated.
Mm-hmm. That's right. Yeah, there's certainly that, desire. And so there's an NLRB decision from 2019 that kind of supports this idea, this inclination on behalf of the employer. It says that confidentiality mandates during the course of workplace investigations are presumptively lawful. It's a case-by-case analysis, but there's a presumption that those are lawful.
Yeah, and that's tricky, Taylor, because I think the bottom line is when two employees talk about safety and health issues at the workplace, that I think that they have a right to engage in a discussion about the terms and conditions of work, and that safety and health is encompassed in terms and conditions of work.
Right.
And that would also apply to maybe an accident. That is a subset of the bigger subject of safety and health. If, however, the National Labor Relations Board's 2019 decision obtains, and the National Labor Relations Board is an area of law which is notorious for flip-flopping every few years compared to other areas of law. But to the extent that the 2019 decision obtains, there is a limited defense for employers who instruct witnesses to maintain confidentiality strictly during the pendency of the interview stage of an investigation.
Yes.
And that to the extent that it is confined in time and directed in purpose to the integrity of the investigation, that an employer has the possibility of raising a defense that doesn't per se run afoul of an employee's Section 7 rights under the Act. The National Labor Relations Act, to be clear, since we're talking about two here. So I think that's frankly a very tricky sort of instruction to give to an employee, and it's tricky for companies to expect their safety and health professionals to get just right. So I think it would require a good bit of training, and to make sure that that the safety and health professionals are comfortable with this instruction and are able to implement it. Well, so let's talk about the effect of the memorandum on promoting of unionization.
Yeah, I mean, this is something that we discussed on a 30/30 episode a while back about the walk around rule. So there's a joint fact sheet was issued around the same time by NLRB and OSHA, so very recently. It's saying unions can add tremendous value to the health and safety programs, at all stages. Now you have this sort of collaboration with OSHA and NLRB. The walk around rule is currently pending. The comment period is closed, but there's certainly a lot of concern, a lot that we discussed a lot of that on our 30/30 about that this could be promoting unionization. I think this is just another sort of step in that direction, and certainly something that employers should be aware of.
That's right. I think that there's no doubt that some unions have some highly experienced staff in the field of safety and health, and that experience presents value to safety and health programs. The concern about the walk-around rule is that in non-unionized workplaces, that expert, no matter how much value they have to offer, is not within the scope of what the original language was provided for OSHA. It has to be necessary, absolutely necessary, to bring in a third party. And to the extent that the safety and health compliance officer has the ability to conduct the investigation, that expertise by a third party union, where unionization hasn't occurred at that work site does not qualify as necessary.
Right, right. I mean, you're bringing a union rep onto a non-unionized work site, and now you're in talking to an OSHA, compliance officer. You're also essentially talking to a representative from the NLRB, and so it's just bringing that the combination of that, puts the employer in, I think, at least new territory and something that they should be prepared for.
That's right, and I don't think it's to the benefit of anybody, including the compliance officer, to cloud the investigation with that kind of complexity. Let's talk about what employers should do.
Sure.
In light of this memorandum of understanding.
Yeah. So I mean, I think we've nailed this one throughout the program today, but cross-train your safety and health team on Section 7 rights, on these sort of NLRA protected activity, concerted activity rights that we've been discussing throughout the program today. Because again, when you're talking to an OSHA compliance officer, they're going to be looking for these things, and you could sort of assume that some of these violations that they pick up on could go directly to the NLRB.
That's right. And I'll tackle two at once. I think that the other thing employers need to do is go back to their handbooks and go back to their standard operating procedures and look at all of the clauses that have been implicated in recent National Labor Relations Board decisions. For example, confidentiality clauses, standard operating procedures about conducting investigations, and the confidentiality instructions that are contained therein. And then the electronic communications policies. There was this newspaper in Seattle, I think, that the claim was that the employer had restricted use of the workplace email, and the allegation was that was a violation of employees' rights to communicate with each other on terms and conditions of work.
Right.
The board agreed, and so here we have another example of a policy that should be reexamined to the extent that employers have legacy policies that are phrased in such ways as to be outdated by that decision.
Right. Right. That's a great point. So then the next one is that investigations focused on safety and health should not encroach on other terms or conditions of work. So again, these investigations, when you're conducting them, to make sure, again, that you're not prohibiting an otherwise protected activity, that if, like we brought up the Weingarten rights, if during the course of one of those investigations, the employee asks for a union representative, just to make sure that even though you think you're in, safety and health land, that you also need to be aware now of these, NLRB rights. Yeah,
the kind of thing an employee might say in response to an internal inquiry might raise other questions, but it's important for the safety and health professional who's conducting the incident investigation to just stick to the safety and health inquiry and get the facts necessary to understand the cause or causes of an incident or accident, and then move forward from there. Right. And trying to be disciplined, show some base discipline in baseball speak on confining the investigation to the purpose of the investigation.
Right, exactly.
I think the other thing I'd say is it's important to take a look at, to the extent that companies have safety committees that are maybe jointly run by safety and health professionals, management, and employees, operators, to reevaluate the structure and the practices of those safety committees and the composition of those safety committees to make sure that they don't accidentally appear to qualify as a employer-dominated union or other sub kind of committee. There is certainly a distinct sort of analysis that should be applied when safety and health is concerned. But again, I think the structure, the practices of that committee, the authorities assigned to the committee, and the composition of the committee will be factors to consider, to evaluate when looking at your current safety committees.
That's right. And then finally, we talked about this one. Remember the Weingarten rights. When you're doing a safety investigation that could result in discipline, it may affect the employee's right to have a representative present, and so to be aware of that and to make sure that you're not, intentionally or unintentionally denying the employee's, request to have that representative there.
Yeah, it's a really great point, Taylor. And that's the last point for this OSHA 3030. Thank you all for participating. This episode, as well as the entire library of 10 years worth of episodes, are stored on our website, khlaw.com, OSHA/OSHA 3030. That's over 120, maybe 125 episodes, all of them very useful to this day, timely and relevant to this day. So check them out. You'll find us on LinkedIn. If you haven't linked in with us, please send us an invite. I know many of you did the last time I asked, and I've accepted all those, and we're now connected on LinkedIn. So thank you. Make sure that both Taylor and I are connected. so that we can stay in touch. The other thing I'd say is this is a podcast as well. So we will be posting this episode and you can get it on your favorite podcast app within a day or so. And it'll be on our website as a video with the slides and the video as well as audio. And that'll be on our website within a day or so as well, channeled through YouTube. So you can also just do a search on YouTube and you'll get our program. Make sure to like and rate on podcast or YouTube so that it's more easily searchable by your peers. The other thing I'd say is the next time you get an invitation to the OSHA 3030, as you've heard me say many times before, we'd be very grateful if you'd forward on that invitation to at least 3 other people within your organization and at other organizations. That is the future of the program. As to the next program, we are going to set up some dates for the year 2024, and we'll announce those in a separate and special email. When you get that list of dates, please forward it on to several other people within your organization and at other organizations, and then go and calendar it accordingly. Also subscribe to the podcast so it just drops in to your podcast app automatically and you can catch it on the go. Right. Our sister programs, the Reach 3030 and the TSCA 3030, are also working on their 2024 schedules. If your organization is responsible for compliance with TSCA or Reach, stay tuned for emails broadcasting those 2024 dates and forward those on once you receive that email as well. Thank you very much to all of you in the OSHA 3030 community for another great calendar year of programming and great content. Without you in the OSHA 3030 community and without you spreading the good word, we wouldn't be able to do this. I want to thank my friend and colleague, Taylor Johnson, for showing up for one more episode out of many we've done together, right?
Yes.
And everyone here in the staff at Keller and Heckman who do such a great job of supporting, bringing this program together every month without miss. Thank you as well. And we look forward to seeing all of you next month on the next OSHA 3030. And until then, stay safe.